Courtrooms are often thought as serious and orderly places. Here are four instances where that was far from the truth. At the number 4 spot comes the unfortunate case of Penelope Soto. While meeting with a judge to determine if she would be in need of a public defender, Penelope couldn't keep a straight face or a serious attitude. When the judge asked Penelope about her assets, specifically her jewelry, she laughed and danced around the value, irritating the judge almost immediately. When the judge pressed for a dollar estimate, she offered such statements as, "It's worth a lot of money," followed by, "like Rick Ross," assumedly referencing the extravagant jewels of artist Rick Ross. The exchange only went downhill from there for Penelope. As the judge dismissed her and said goodbye, she replied with a very sassy "adios," to which the judge laughed. As she walked away, the judge called her back again, immediately doubling her bail to $10,000. A shocked Penelope gasped and muttered, "Are you serious?" as the judge dismissed her again. As she turned on her heel, she couldn't help but let out a few expletives towards the judge, as well as flashing her middle finger over her shoulder. As you can imagine, the judge did not take very kindly to this. After a brief back and forth, he found her in contempt of court and sentenced her to 30 days in the county jail. Number 3. Michael Marin. Michael Marin was a wealthy stockbroker who made his millions from trading securities in the 80s. He was living in a multi-million-dollar home in Arizona. Unfortunately, in 2009, the money slowed down and his mortgage sped up, and soon Michael was drowning. He soon devised a plan to get rid of the house by hosting a lottery, seeking to make a little money and free himself from the mortgage. Unfortunately for him, state authorities determined that the lottery was illegal and could not go through. Mysteriously, the day after he received that news, his house got burned down. Authorities quickly discovered evidence of his arson, and he was found guilty in court. As his verdict was read, he was seen putting his hand to his mouth and then taking a sip of water. Soon after, he collapsed on the floor convulsing. He was pronounced dead at the hospital. His cause of death, cyanide poisoning. In the number 2 spot is the Scopes monkey trials. On July 10th of 1925, a peculiar trial began in Dayton, Tennessee. A man by the name of John Thomas Scopes, a high school teacher in Dayton, was to stand trial for violating a misdemeanor statute that forbade the teaching of any theory that denies the story of divine creation of man as taught in the Bible, and to teach instead that a man has descended from a lower order of animals. Although Scopes was a science teacher in Dayton, he never surely taught evolution as the truth to his students. Instead, Scopes conspired to draw national attention to the issue by intentionally getting himself in trouble. Enlisting the help of the American Civil Liberties Union, Scopes hoped to become a martyr for the case, at least so far as a misdemeanor conviction and the associated $100 fine could make him such. Joining the prosecution was 3-time presidential candidate William Jennings Bryan, only adding to the media frenzy of this already interesting case. Soon after, Clarence Darrow, a famous attorney of the time, agreed to join the ACLU defense. The crowds drawn were so severe that eventually the judge had to order the trial to be moved to the courthouse lawn for fear of the floor collapsing. Eventually, the trial came to a head when Darrow called William Jennings Bryan to the stand, subjecting him to lines of questioning which exposed his ignorant and contradictory views when interpreting the Bible literally. Darrow had won the crowd and the jury. However, in a bizarre twist, he asked for a guilty verdict, so that the case might be appealed to a higher court and a legal precedent may be set. 2 years later, the Tennessee Supreme Court overturned the verdict due to the legal technicalities, but did not make a judgment on the constitutional issues revolving around this case. Although the Scopes trial did not achieve its ultimate goal of a Supreme Court ruling on the matter of constitutional rights, the defense at least won in the court of public opinion. At the number 1 spot is the curious case of Ernie Turgold. In August of 2013, a man named Ernie Turgold was accused of fishing without a license at Three Forks Pond in Montana, as well as resisting arrest. What makes this case so interesting is that within 30 minutes of the court proceedings beginning, the 52-year-old man was kicked out of court for his constant interruptions and accusations. While this alone isn't completely irregular, the message that Ernie has for the court is. He asserted that he was the living man and by virtue he had the unalienable right to forage for food when he was hungry, telling the judge, "I was searching for something to put in my stomach, as I'm recognized to be able to do by the universal law. I am the living man, and I have had the right to forage for food when I'm hungry." When asked if he would like to go to trial, as he had pled not guilty to both charges, Ernie responded with, "I never plead. Animals plead. Sounds like bah, oink, oink." Shockingly, or perhaps not, the judge at this point got so fed up with Ernie's antics that he personally got up and walked out of the courtroom.